The world of business can often feel, well, incredibly intricate, right? A dense web of regulations and structures.
It really can.
But if we sort of pull back the layers, we find it's built upon some really fundamental principles.
That's right.
And today, we're diving deep into one of the most crucial foundations, the Companies Act, 2013.
Exactly. Think of this act as the essential framework. It governs how companies in India come into existence, how they operate day to day.
It's a big piece of law.
It is substantial, yeah. But within it are core ideas that are just vital for anyone involved in the commercial landscape, from people starting their own ventures to seasoned investors.
So our aim in this deep dive is really to extract the most important knowledge from our source material. We want to unravel how companies are formed, the maybe surprisingly diverse forms they can take.
Yeah.
That really key legal distinction between a company and the individuals who own it, and those all-important documents that essentially give a company its DNA, its operating instructions.
And as we explore these, we'll also touch on some pretty interesting legal ideas, like this concept of a corporate veil.
Ah, yes, the veil.
That legal separation between a company and its members, and importantly, under what specific, sometimes surprising circumstances that veil can actually be lifted.
Pierced, even.
Right.
And of course, we can't forget the foundational blueprints, the Memorandum of Association, the MOA, and the Articles of Association, the AOA. We'll get into what these are and why they hold such significance in shaping a company's existence and, well, how it functions internally.
Sounds good.
Okay, let's get right into it then. In the eyes of the law, what fundamentally is a company?
Well, the Act itself gives a straightforward definition in Section 220. It just says, company means a company incorporated under this Act or under any previous company law. Simple enough.
A bit circular, maybe.
A little bit, yeah. But to really grasp the essence, it's helpful to look at some classic interpretations. Chief Justice Marshall, for instance, described a corporation as an artificial being, invisible, intangible, existing only in contemplation of law.
Invisible and intangible. That paints this picture of a legal construct, something that exists on paper, not a physical thing.
Exactly. It's an idea given legal form.
Like an organization personified by the law.
Precisely. And Professor Haney added to this, defining a company as an incorporated association, which is an artificial person created by law, having a separate entity with a perpetual succession and a common seal.
Okay, those phrases, separate entity, perpetual succession, common seal, they seem key.
They really underscore the core characteristics that set a company apart from, say, a partnership or a sole trader.
So let's delve into those characteristics. First up, separate legal entity. What does that separation mean in practice?
This is absolutely foundational. Once a company is officially registered, it gains its own distinct legal identity. It's treated as a separate person under the law.
Totally apart from its members, the shareholders.
Entirely apart. This means the company itself can have rights and responsibilities. It can own property, have its own bank account, take out loans, incur debts, enter into contracts, all in its own name.
So the people who own the shares, they're legally distinct from the company in these matters.
Absolutely, and that distinction is critical. It even means members can enter into contracts with their own company.
Really?
Yes, and importantly, if the company gets into debt, creditors pursue the company, not the shareholders personally. There's a really illustrative case here, Makara Visa's Northern Assurance Co. Limited.
Ah, 1925. The timber insurance one, right?
That's the one. Mr. Makara owned pretty much all the shares in a timber company, and he was also a creditor. He insured the company's timber against fire.
Okay.
But crucially, he took out the policy in his own name, not the company's name.
I see where this is going.
Exactly. When the timber burned down, the insurance company refused to pay him.
Why? Because he wasn't the legal owner of the timber.
Precisely. The court said the timber belonged to the company, that separate legal entity. Since the policy was in Makara's personal name, he didn't have a direct insurable interest just because he was a shareholder.
Wow, that really hammers home the separation. The company's assets are strictly its own.
Couldn't put it better.
Okay, next key feature. Perpetual succession. That sounds like the company just keeps going.
That's a good way to think about it. Unlike, say, a sole proprietorship that ends when the owner dies, or a partnership that might dissolve if a partner leaves.
Right.
A company's existence just carries on. It's uninterrupted, even if shareholders sell their shares or pass away. The company only ceases to exist when it's formally wound up through a specific legal process.
So a company could literally outlive generations of its founders and members.
Exactly. Our source mentions companies in India over 100 years old, and it poses that classic hypothetical, even if all 7 members of a public company died in a plane crash.
The company would still exist.
Legally, yes. The shares would pass to their heirs, maybe, but the corporate entity itself would continue its legal life. That stability is a huge advantage.
Definitely highlights the resilience of the structure. Okay, next. Limited liability. This is often the big draw, isn't it?
It certainly is.
Yeah.
Hugely attractive. How much a member can be held responsible for the company's debts really depends on the type of company.
Okay.
In a company limited by shares, which is the most common type, by far, a member's liability is capped. It's limited to the amount, if any, that's still unpaid on the shares they agreed to buy.
So if I buy shares and pay the full price for them,
Then generally that's it. You can't usually be asked to chip in more money to cover the company's debts if things go wrong.
that provides a pretty significant level of personal financial protection, doesn't it? Makes risk-taking more manageable.
Exactly. It encourages investment. Now, there are other forms, like a company limited by guarantee, where members pledge a certain amount payable only if the company winds up, often used for nonprofits. And you also have unlimited companies where, well, the name says it all. Member liability isn't limited, but those are much less common. For most businesses, limited liability by shares is key.
Got it. Okay, moving on to artificial judicial person. Sounds a bit sci-fi.
Light chuckle. It does, doesn't it? But it just means the company, as this distinct legal entity created by law, is treated as a person for many legal purposes.
Like having rights.
Exactly. It has the legal capacity to own property, enter into contracts, sue other parties, and be sued in its own name. It's a subject of legal rights and duties.
But it's not a real person, obviously. So what are the limitations? What can it do?
That's the crucial distinction. A company can't be put in jail, it can't take an oath in court personally, it can't get married, or practice a learned profession like medicine or law that requires personal qualifications.
So it needs people to act for it.
Right. It operates through human agents. Typically, it's directors who manage its affairs. They act for the company, but they aren't technically the personal agents of the shareholders.
Okay, the company acts through its board and officers. And the last core feature mentioned is the common seal. That feels a bit old-fashioned.
It is a bit of a historical artifact, you're right. Traditionally, it was the official signature of the company. You'd physically press the seal onto important documents.
Like a corporate stamp of approval.
Literally,
Right.
yes. But the Companies Amendment Act in 2015 recognized that, in the modern world, this isn't always practical or necessary, so they made having and using a common seal optional.
Why the change, do you think? Easier administration.
Probably streamline things, yeah. Physical seals can be cumbersome, especially with digital documents. Electronic signatures and other forms of authorization are just more efficient now.
Makes sense.
So now, if a company decides not to have a common seal, documents that used to need it can be validly signed off by 2 directors, or by 1 director and the company secretary, if there is one.
Interesting how even these fundamental bits evolve. Okay, so those are the essential characteristics defining a company. Now let's circle back to that intriguing concept, the corporate veil theory. What exactly is this veil?
Okay, imagine this veil as an invisible but legally powerful barrier. It sits between the company and its members.
The shareholders.
Primarily the shareholders, yes. It's the law's way of recognizing the company as separate. And this separation provides a crucial shield for the members, protecting them from being personally liable for the company's debts or actions. Our source calls it corporate insulation.
So it flows directly from that limited liability idea we just talked about.
Exactly. It's the practical consequence of it. And the foundation for this whole theory was really cemented in a landmark case, Salomon v. Salomon & Co. Ltd.
Salomon. That's the big one, isn't it? Remind us of the situation there. Sounds like the lines got a bit blurry.
They did, or at least that's what the creditors argued. Mr. Salomon was a sole trader running his own business. He decided to incorporate it, forming Salomon & Co. Ltd. He and his family were the only shareholders. The new company bought his old business. In return, Salomon got shares in the new company, debentures, which are basically loans acknowledging the company owed him money and some cash.
So he was both owner and a major creditor.
Exactly. Later, the company hit financial trouble and went into liquidation. The company's other creditors, the unsecured ones, argued that Salomon shouldn't get paid back first for his debentures.
Why not?
They argued he was the company. that it was just a sham, a facade for his personal business, and he shouldn't be treated as a separate secured creditor. They wanted to hold him personally liable.
So they wanted to ignore the company's separate status, to pierce the veil.
That was precisely their goal. But the House of Lords, in a really pivotal judgment, shut that down. Lord MacNaughton famously said, "The company is at law a different person altogether from the subscribers."
Even if one person controls it all.
Even then, he stressed that the company wasn't just Salomon's agent or trustee. The business might be the same, the people the same, but the legal entity was distinct, and the members' liability went limited by the act.
So Salomon really hammered home that principle.
Yeah.
The company is its own legal person.
It did. The whole structure of modern company law with limited liability rests heavily on that Salomon decision. But the story doesn't quite end there.
There's always a but.
Well, the law also recognizes that this protective veil isn't absolute. In certain specific situations, the courts can decide to lift or pierce it.
Lift the veil. That sounds significant. When would a court disregard that separate entity status?
It's not done lightly. It's usually reserved for situations where sticking rigidly to the separate entity principle would lead to injustice or maybe shield fraud or go against public policy.
Okay, what are some examples?
Our source lists several scenarios. One is to determine the character of the company. This often comes up in wartime. Is a company registered here actually controlled by enemies?
So looking behind the registration to see who's really pulling the strings.
Exactly. The Daimler Co. Ltd. versus Continental Tire and Rubber Co. case is key here. They looked at who controlled the company to decide if it was an enemy during World War I.
Makes sense in a national security context. What else?
Another big one is to protect revenue or tax. If it's clear a company is just being used as a shell or a device to dodge taxes.
Like funneling income through it to avoid personal tax.
Precisely. The courts can ignore the separate entity. The Dinshaw Manakji Pettit case is a classic example. An individual set up several companies just to receive his investment income, disguising it as loans back to himself to avoid tax. The court saw right through it.
So you can't just use the company structure purely as a tax dodge.
Not if it's clearly artificial. Another reason is to avoid a legal obligation. The workmen employed in Associated Rubber Industries Limited case is relevant here.
What happened there?
A company transferred assets to a new subsidiary, seemingly to reduce its own declared profits, and therefore cut the bonus it legally had to pay its workers.
Trying to use the structure to get around obligations.
Exactly. The Supreme Court lifted the veil, looked at the reality of the transaction, and prevented the company from using the subsidiary structure to avoid paying the bonus.
So the courts look at the substance, not just the form, if there's a suspicion of dodging responsibility.
That's a key takeaway. Similarly, if subsidiaries are set up just to act as agents for the parent, essentially having no independent business purpose.
Like in the Merchandise Transport Limited case, where they tried to get licenses through a subsidiary.
Exactly that one. The court might treat the whole group as one entity. They look for genuine separation of business.
Not just structures for convenience or, well, dodging rules.
Right. And maybe the most fundamental reason is when a company is formed specifically for fraud or improper conduct or to deliberately defeat the law. Think of the Guilford Motor Company versus Horn case.
What was that about?
Horn was bound by a non-compete clause after leaving Guilford Motor Co. He set up a new company, basically run by him and his wife, to carry on competing business, trying to use the company's structure to shield himself from the non-compete.
Did it work?
No. The court lifted the veil and issued an injunction against both Horn and his company, recognizing it was just a device to breach his obligation.
So, using the company as a cloak for fraud or illegality is a definite trigger for lifting the veil. It maintains the integrity of the whole system.
Absolutely. The corporate form is a privilege granted by law. It's not meant to be a tool for wrongdoing.
Okay, that clarifies the veil and when it might be lifted. Now let's explore the different types or classes of companies the Act recognizes. Seems like quite a variety.
There is, yeah. The Act categorizes them based on several things: member liability, number of members, control structure, access to capital, and some other specific types too.
Let's start with liability since we've touched on that. What are the main types there?
Well, as we said, the most common is the company limited by shares liability capped at the unpaid share amount.
Right.
Then you have the company limited by guarantee. Here, members pledge a specific sum, usually payable only if the company winds up. You often see these for clubs, charities, nonprofits.
So the focus isn't initial share capital, but a promise to contribute later if needed.
Exactly. And finally, there are unlimited companies. As the name implies, member liability isn't capped. Much rarer for obvious reasons.
Understandably. Okay, liability is one way to slice it. What about based on the number of members?
Here we have one-person companies, OPCs, private companies, and public companies. The OPC is relatively new from the 2013 Act.
To help solo entrepreneurs.
Exactly. It lets one person form a company with separate legal status and limited liability. But there are rules.
Like?
The person must be an Indian citizen and resident in India for at least 120 days in the previous year. They also have to nominate someone to take over if they die or become incapacitated.
A succession plan built in.
Right. And you can only have one OPC, you can't be a nominee in more than one, and OPCs can't be Section 8 companies, the charitable ones, or do non-banking financial investment.
So some restrictions, but it formalizes single-person businesses.
It does. Then we have private companies.
Which are more restricted in membership.
Yes. Their articles must restrict the right to transfer shares. They also limit the number of members to 200, though current and former employees who are members don't count towards that limit.
Okay.
And crucially, they're banned from inviting the public to subscribe to their shares or debentures. There used to be a minimum capital requirement, but that's gone now.
And within private companies, there's the small company category.
Right. A small company is a type of private company meeting certain thresholds for paid-up capital, currently not over 4 crores, and turnover not over 40 crores. These figures were updated in 2022.
And they get, what, maybe simpler compliance?
Often, yes. But holding companies, subsidiaries, Section 8 companies, and companies under special acts can't be small companies, even if they meet the financial criteria.
Got it. So that leaves public companies.
Which are basically anything that isn't a private company. They need at least 7 members to start, but there's no upper limit.
And their shares.
Generally freely transferable, often listed on a stock exchange. And they can invite the public to invest.
Okay.
A key point here. If a private company becomes a subsidiary of a public company, it's legally deemed to be a public company itself, even if its articles haven't changed.
Ah, that deemed public status is important for regulations, I bet.
Big time. It triggers a lot more compliance requirements.
Okay. What about classifying companies based on control?
This brings us to holding companies, subsidiary companies, and associate companies. A holding company is one that controls another company, the subsidiary.
And control means?
Either controlling the composition of the subsidiary's board of directors, like appointing or removing the majority of directors, or holding more than half of the total voting power in the subsidiary.
So majority control, essentially.
Pretty much. And a subsidiary can itself be a holding company for another subsidiary, creating layers.
Corporate structures. And what's an associate company?
That's where one company has significant influence over another, but not full control.
Significant influence. How is that defined?
It means holding at least 20% of the total voting power, or having control over or significant participation in business decisions under an agreement. Joint ventures often fall into this category too.
So a step below subsidiary status, but still a meaningful connection.
Exactly.
Okay, control. Robert, what about access to capital markets?
Simple distinction here. Listed companies and unlisted companies.
Listed means?
It means any of its securities, shares, debentures, etc. are listed on a recognized stock exchange so the public can trade them.
And unlisted is just not listed.
Right. Any company whose securities aren't on an exchange, listing comes with a whole host of extra regulations and disclosure requirements, obviously.
To protect investors and ensure market transparency.
Precisely. The source mentions Scan Steel Rods Limited getting penalized for non-compliance, showing these rules have teeth.
Okay. And finally, that other companies category. What falls in there?
A few specific types. First, government companies. That's where 51% or more of the paid-up share capital is held by the central government or one or more state governments, or jointly.
Majority government owned.
Yes, and it includes subsidiaries of such companies too. The definition also clarifies that paid-up share capital can mean total voting power if there are shares with differential voting rights.
Okay. What else is in this other group?
Foreign companies. These are incorporated outside India but have a place of business here, maybe an office or agent, and conduct business activity in India.
Makes sense.
Then you have Section 8 companies. These are specifically formed to promote charitable objects, things like commerce, art, science, sports, education, social welfare, religion, environmental protection.
Nonprofits, essentially.
Exactly. They need a license from the central government, usually delegated to the Registrar of Companies, ROC now. They must apply their profits to their objects and are prohibited from paying dividends to members.
And they get a special status.
Yes, a key benefit is they don't have to use limited or private limited in their name. Often they use words like foundation, forum, association.
Signals their nonprofit nature.
Right. But the license can be revoked if they violate conditions, which could lead to winding up or merging with another Section 8 company. They also have some procedural relaxations, like shorter notice periods for meetings sometimes. And interestingly, partnership firms can be members.
Flexible structure for charitable work. What else?
Dormant companies. This is under Section 455. A company formed for, say, a future project or just to hold an asset like intellectual property but which has no significant accounting transactions can apply for dormant status.
What counts as significant?
The Act defines it. Basically, any transaction other than paying ROC fees, fulfilling legal requirements, making payments to maintain its office and records, or allotting shares to meet Act requirements. An inactive company is one that hasn't done business or has significant transactions for 2 financial years or hasn't filed financials and returns for 2 years.
So it allows a company to pause operations legally.
Essentially, yes. It keeps its registration without the full compliance burden of an active company. Useful for holding assets or for projects on hold.
Okay. Any others?
Needy companies. These are a type of non-banking financial company focused on borrowing from and lending to their own members only. Think mutual benefit societies encouraging saving.
Right.
And lastly, public financial institutions, PFIs. These are major institutions like LIC, IDFC, specified infrastructure finance companies, etc., either set up by an act of parliament or state legislature, or where the government holds at least 51% of the capital, and which are specifically notified as PFIs by the government.
Okay, that's a really comprehensive rundown of the company types. Now, how do these actually get started? The mode of registration or incorporation? Who kicks things off?
It usually starts with the promoters. Section 269 defines them. They're the ones who conceive the idea, take the first steps to form the company, and get it registered.
The driving force behind it.
Exactly. They might be named in the prospectus or annual return, or they might have control over the company's affairs, or the board might be accustomed to acting on their instructions.
Are professionals involved in setting it up considered promoters? Lawyers, accountants?
Generally, no. If they're just acting in their professional capacity, advising, drafting documents, they aren't considered promoters. It's about initiating and driving the formation.
Got it. So the promoters have the idea. What's next?
The actual formation. Section 3 specifies the minimum numbers needed to subscribe to the memorandum. 7 or more for a public company, 2 or more for a private one, and just 1 for an OPC. They sign the MOA and comply with registration rules.
And then the formal incorporation process, filing the paperwork.
Exactly. Section 7 lays this out. You have to file several documents and information with the Registrar of Companies, the ROC.
What kind of documents?
The signed memorandum and articles of association are key. Plus, declarations from each subscriber and the first directors named in the articles confirming they've complied with all the Act's requirements for incorporation.
Okay.
You also need a declaration from a professional involved, a lawyer, CA, cost accountant, or company secretary in practice, stating that all legal requirements for registration have been met.
Seems thorough.
It is. You also need details of the subscribers and first directors, names, addresses, proof of identity, etc., and their written consent to act as directors. Any interest they have in other firms needs disclosure too.
Why all this detail up front? Accountability.
Absolutely. Transparency right from the start. It lets the ROC and future stakeholders know who's behind the company.
Okay, so all documents are filed. What does the ROC do?
If the ROC is satisfied that everything is in order and complies with the Act, they register the company and issue a certificate of incorporation.
The official birth certificate.
Pretty much. That certificate is conclusive evidence the company legally exists from that date. The ROC also assigns a unique corporate identity number, the CIN.
And the company has to keep records.
Yes, it must maintain copies of all the incorporation documents at its registered office.
What if someone lied during incorporation? Furnished false information?
The Act takes that very seriously. Providing false info or suppressing material facts can lead to liability for fraud under Section 447.
Which means?
Significant penalties, potentially imprisonment, and hefty fines for those involved, including the promoters and first directors.
Yeah, what about the company itself if it was formed based on false information?
The National Company Law Tribunal has broad powers. It can order changes to the company's management, declare the members have unlimited liability, order the company's name struck off the register, or even order it to be wound up.
Wow, serious consequences. Integrity at formation is clearly paramount.
It absolutely is. Our source also mentions SPICE.
Ah, yes, the simplified pro forma for incorporating company electronically, making it easier online.
Exactly. A single electronic form to streamline the whole process, aiming for faster and easier registration. A move towards ease of doing business.
Okay, so the company gets a certificate. What's the legal effect of that registration?
Section 9 covers this. From the date on the certificate, the subscribers and all future members become a body corporate by the name in the MOA.
A legal entity.
Yes. With perpetual succession, the power to own property, enter contracts, sue, and be sued in its own name. It's legally alive from that moment.
And the case law backs this up strongly.
Absolutely. Cases like Hari Nagar Sugar Mills confirm a binding contract exists between the company and members via the MOA-AOA from registration. State Trading Corporation of India confirms the separate legal existence right away. Even if the government owns all shares, Heavy Electrical Union, or one company buys all shares of another, Spencer & Co., they remain distinct legal entities.
The principle of separate legal personality is ironclad from incorporation.
Precise.
And what about the MOA and AOA themselves, once registered? What's their legal force?
Section 10 is key here. It says the registered MOA and AOA bind both the company and its members as if they'd each personally signed them.
So they form a binding contract?
Yes. All the provisions are enforceable. And any money a member owes the company under the MOA or AOA is treated as a legal debt owed to the company.
So they're not just internal guidelines. They have real legal teeth, defining that core relationship.
Exactly. They set the rules of the game.
Okay, let's shift gears slightly to the financial structure, the classification of capital. Seems capital can mean different things.
It can, depending on context. But for companies limited by shares, we usually talk about share capital. Our source breaks this down into several categories.
We'll start at the top. Nominal, authorized, or registered capital. What's that?
Section 2.8. This is the maximum amount of share capital the company is legally allowed to issue, as stated in its MOA. It's the ceiling.
The upper limit it can raise through shares.
Right. And it's the figure used to calculate the initial stamp duty when registering. It sets the potential scale.
Okay, maximum authorized. What's next?
Issued capital, Section 250. This is the portion of the authorized capital that the company is actually offered for people to subscribe to.
So not the maximum possible, but what they've put out there.
Exactly. It includes shares offered to the public and also shares allotted for reasons other than cash, like buying an asset. Companies have to show this figure on their balance sheet.
So authorized is the limit. Issued is what's been offered. Then comes subscribed capital.
Right. Section 286. This is the part of the issued capital that people have actually agreed to take up, that members have subscribed for.
The amount investors have committed to.
Yes. And there's a rule. If a company mentions its authorized capital anywhere official, it must also state its subscribed and paid up capital clearly.
Why? For a more realistic picture.
Exactly. Authorized capital might be huge, but subscribed shows the actual investment commitment secured, prevents misrepresentation. Failure means penalties under Section 60.
Okay. Next down the chain, called up capital.
Section 215. This is the portion of the subscribed capital that the company has actually asked the shareholders to pay.
So the company might not ask for the full subscribed amount all at once.
Correct. They might call for payments in installments as the business needs funds. Called up capital is the total amount called so far.
The amount shareholders have been formally asked to pay, which leads finally to paid up capital.
Exactly. This is the bottom line, financially speaking. It's the total amount of money the company has actually received from shareholders for their shares, or the amount credited as paid up.
So it's called up capital minus any amounts still outstanding, calls in arrears.
Precisely. Paid up capital is the real cash or equivalent that's come into the company's coffers from share issues.
Okay, that clarifies the different layers of capital. Now, what about the units themselves? Shares. Legally, what is a share?
Section 284 defines it as a share in the company's share capital, including stock. Think of it as representing a shareholder's proportionate slice of ownership.
A stake in the company.
Yes, measured by the money paid or payable on it. But it's more than just ownership. It's a bundle of rights defined in the contract between the shareholder and the company, rights to dividends, voting, etc. That's how Justice Farwell described it in the Borland Trustees case.
But holding a share doesn't mean you own the company's actual assets, right?
Crucially, no. Shareholders don't own the factory or the intellectual property directly. The company owns its assets. The share is an interest in the company.
Got it. And these shares, they're movable property. Can they be transferred?
Yes, Section 44 makes that clear. Shares are movable property, transferable according to the company's articles. And Section 45 says each share usually needs a distinct number unless they're held electronically in a depository.
That transferability is key for public markets, isn't it? Liquidity.
Absolutely essential. If you couldn't easily sell your shares, investing would be far less attractive.
Okay. What different kinds of share capital can companies issue?
Section 43 outlines two main kinds: equity share capital and preference share capital.
Equity is the basic ownership.
Yes. These usually carry voting rights, often one share, one vote. But companies can also issue equity shares with differential rights regarding dividends, voting, or other things, as long as they follow specific rules.
Differential rights, like some shares having more votes than others?
Exactly. Or maybe different dividend entitlements. The source mentions Tata Motors A equity shares as an example, fewer voting rights, but maybe a slightly higher dividend sometimes.
Why allow that? To let founders keep control.
That's often a key reason, yes. Allows founders to raise capital without losing control over decisions.
Okay. And the other type is preference share capital.
Right. As the name suggests, these shares carry certain preferential rights over equity shares.
Like what?
Primarily two things: dividends and capital repayment. They usually get paid a fixed dividend amount or rate before any dividend is paid to equity shareholders.
First dibs on profits distributed.
Exactly. And if the company is wound up, they usually have the right to get their capital investment back before equity shareholders get anything.
So lower risk in some ways, but maybe less upside potential than equity.
Generally, yes, though there's an exception to note. For private companies, their MOA or AOA can actually override these standard rules in Section 43, allowing more tailored capital structures.
More flexibility for private companies again.
Yeah.
Okay, let's finally turn to those foundational documents we mentioned at the start. The Memorandum of Association, the MOA. What's its core role?
The MOA is often called the company's charter or constitution. It's the absolute bedrock document. It defines the company's purpose, its objectives, the scope of what it's allowed to do.
So it sets the boundaries, the legal limits.
Precisely. It lays down the perimeter fence for the company's operations. Think of it as the company's legal DNA.
And why is registering it so important?
Several reasons. It clearly defines the objects so shareholders know how their money should be used and the risks involved. It tells creditors and anyone dealing with the company what its powers are. And crucially, a company legally cannot act beyond the scope of its MOA.
That sounds like the doctrine of ultravirus we touched on earlier.
Exactly. We'll get back to that. The MOA is also a public document under Section 399, so everyone is presumed to know what's in it.
Okay, vital for internal and external understanding. What must be in the MOA? The compulsory clauses.
Section 4 lays these out. First, the name clause. The company's name, ending with limited for public or private limited for private companies.
Except for Section 8 companies.
Right. They have different naming rules, often using foundation, association, etc. Government companies must use limited, and OPCs have to add one-person company below their name.
Okay. Name clause. What else?
Second, the registered office clause just specifies the state where the registered office is located. Doesn't need the full address here, just the state.
Third.
The object clause. This is critical. It states the main purposes for which the company is formed and any activities necessary to achieve those purposes. If a company changes its activities significantly later and the name doesn't reflect that, it needs to change its name within 6 months.
So the objects define the core business. What's next?
Fourth, the liability clause. States if member liability is limited or unlimited. If limited by shares, it has specific wording about liability being limited to the amount unpaid on shares. If limited by guarantee, it states the amount each member guarantees to contribute on winding up.
Clear statement of liability.
Fifth, the capital clause for companies with share capital. Specifies the total authorized share capital, how it's divided into shares of a fixed value, and how many shares each initial subscriber is taking, minimum 1 each. Not needed for guarantee companies without share capital.
Defines the initial financial structure. And finally,
the association clause, or subscription clause, lists the subscribers' names, addresses, etc., stating their desire to form the company and agreeing to take shares. Minimum 7 for public, 2 for private, 1 for OPC. For OPCs, it also names the nominee.
So it covers identity, purpose, liability, capital, and the initial members. Are there rules about how the MOA document itself should look?
Yes. It must be printed, divided into numbered paragraphs, and signed by all subscribers in front of at least one witness, who also signs and attests with their details.
Signatures are key. Can anyone sign?
A company can subscribe through an agent, but a minor cannot be a subscriber. If a guardian signs for a minor, the guardian is personally liable.
Important distinction. Can companies add other things to the MOA beyond these clauses?
Yes, they can include other provisions like rights for different share classes, as long as they don't contradict the company's act itself. Anything in the MOA contrary to the act is void, and all other company documents, like the articles, must comply with the MOA.
So the MOA is supreme. Now let's properly unpack that doctrine of ultra vires you mentioned. Beyond the powers. What does that mean in practice?
It's a fundamental rule. It means a company can only legally do things that fall within the objects stated in its MOA, as allowed by the Act. Anything else, any act or contract that goes beyond those stated powers,
Is invalid.
it's considered wholly void and legally ineffective right from the start. Ultra vires acts have no legal standing.
So if a company whose MOA says it makes, furniture, tries to enter a contract to operate an airline,
That contract would likely be ultra vires and void. The company couldn't be sued to perform it, nor could it sue the other party to enforce it.
because it's outside its legal capacity.
Exactly. And since the MOA is public, the other party is deemed to know the company lacks the power to make that contract. They can't usually claim ignorance.
Are there any nuances? What if money changes hands?
There are some subtleties. For instance, if a company borrows money ultra vires but hasn't spent it yet, the lender might be able to get an injunction to stop them spending it and recover it. Or, if the ultra vires loan was used to pay off legitimate debts, the lender might step into the shoes of the creditor who was paid off. But the contract itself remains void.
Okay. Can an ultra vires act ever be fixed later? Can shareholders vote to approve it?
This is crucial. An act that is truly ultra vires the company, i.e. beyond the MOA's object clause, cannot be ratified or made valid, not even if every single shareholder agrees, because it goes to the fundamental legal capacity of the company, which is defined by the MOA for the protection of everyone involved. You can't ratify something that was legally impossible from the start.
But what about acts that are just beyond the director's powers but still within the company's objects?
That's different. If directors exceed their authority, but the act itself is within the company's overall powers, intra vires the company, the shareholders can usually ratify it later. Similarly, if an act is against the rules in the Articles of Association, ultra vires the articles, but still within the MOA's scope, the company can usually alter its articles by special resolution to allow it. And irregular internal procedures for acts within the company's power can often be validated by shareholders too.
So the key is whether it's ultra vires the MOA itself. That's the absolute barrier. You mentioned a key case.
Yes, the classic case is Ashbury Railway Carriage and Iron Company Limited v. Risch back in 1875.
What happened there?
The company's MOA said its objects were things like making railway carriages, mechanical engineering, general contracting. The directors made a contract to finance building a railway line in Belgium.
Don't sound like making carriages.
Exactly. Even though general contractors was in the MOA, the House of Lords said financing a railway was fundamentally different and outside the scope of the objects read as a whole.
And even though shareholders later approved it.
Didn't matter. The contract was deemed ultra vires the company from the start and therefore void. Couldn't be ratified. The case firmly established that ultra vires acts can't be validated by estoppel, delay, or shareholder approval.
Really locks down the importance of the object clause. So summarizing ultra vires.
Company power is limited by MOA. Acts beyond MOA are void, can't be ratified, protects shareholders and creditors by defining the business scope.
Has its impact lessened over time?
Somewhat, yes. Originally, it was quite rigid. But modern company law makes it much easier to alter the object clause in the MOA, usually just needing a special resolution from shareholders.
So companies can adapt more easily now if they want to change direction.
Exactly. That flexibility has reduced the number of strict ultra vires problems we see today, though the underlying principle remains important.
Okay, now for the other key document. The Articles of Association, the AOA. How does this differ from the MOA?
If the MOA is the Constitution, the AOA is the internal rule book or bylaws. It governs the internal management and administration of the company.
So how the company runs itself day to day.
Precisely. It details things like the powers and duties of directors, rules for holding board meetings and shareholder meetings, voting procedures, how shares are transferred, especially in private companies, appointment of auditors, declaration of dividends, all the operational mechanics.
Lord Cairns, in the Ashbury case, called it subsidiary to the memorandum.
Yes, meaning it operates within the framework set by the MOA. It details how the objects in the MOA will be achieved internally. The SS Rajkumar case called it a business document to be construed strictly. It mainly regulates the internal relationships between the company and its members and among members.
And auditors need to study it.
Definitely. To understand the company's governance structure and ensure compliance with its own rules.
So what kind of things does Section 5 say should be in the articles?
It says the AOA shall contain regulations for management. It can include specific matters prescribed by the rules, plus anything else needed for management. It also allows for those entrenchment provisions we mentioned earlier.
The ones making certain rules harder to change.
Exactly. Making alteration require a stricter condition than a normal special resolution. If you include entrenchment, you have to notify the ROC.
And there are model articles, like templates.
Yes. Tables F to J in Schedule, I provide model articles for different types of companies, like Table F for a company limited by shares. A company can adopt these fully, partially, or have its own custom articles.
What if a new company doesn't register any specific articles?
Then the relevant model articles automatically apply to it unless they're specifically excluded or modified in the MOA or by the company later.
So there's always a default set of internal rules. Let's quickly recap the key differences between MOA and AOA.
Okay. MOA defines objects and powers, external capacity. AOA governs internal management, operational rules. MOA defines relationship with outside world. AOA regulates internal relationships. MOA. Alteration usually harder, special resolution, maybe external approval. AOA. Alteration usually by special resolution only. MOA. Acts beyond it are ultra vires and void, cannot be ratified. AOA. Acts beyond it, but within MOA, can often be ratified by shareholders.
That's a clear summary. Okay, final core concept for today, the doctrine of indoor management. You mentioned it's an exception to constructive notice. Let's unpack that. What's constructive notice first?
Right. So Section 399 allows anyone to inspect key company documents like the MOA and AOA filed with the ROC. Because they're public.
The law assumes you know what's in them.
Exactly. That's constructive notice. Whether you've actually read them or not, you're legally presumed to know their contents. So you can't later claim ignorance if a transaction clearly violates the MOA, for example.
Puts the onus on the outsider to check the public documents. Seems fair, but maybe harsh.
It can be, which is why we have the exception. The doctrine of indoor management, also known as the Turquand Rule.
Okay, how does that work?
It essentially says, while outsiders are expected to know the company's public documents, MOA, AOA, they are not expected to know about the company's internal workings or whether all internal procedures and approvals have been correctly followed.
Why is that distinction important?
Think about it. It would be completely impractical for every person dealing with a company to have to investigate its internal meeting minutes or confirm if every internal resolution was properly passed. Business would grind to a halt.
True. You'd never get anything done.
Exactly. So the doctrine of indoor management protects outsiders acting in good faith. It allows them to assume that the company's internal procedures have been properly complied with, as long as the transaction itself appears consistent with the powers granted in the MOA and AOA.
And the key case here is the Royal British Bank versus Turquand.
That's the one. Landmark case.
Remind us what happened.
The company's articles allowed directors to borrow money, but only if authorized by a shareholder resolution. The directors borrowed money from the bank, issuing a bond signed by 2 directors and the secretary.
Okay.
Later, the company tried to get out of repaying, arguing the necessary shareholder resolution hadn't actually been passed internally.
But the bank wouldn't have known that.
Precisely. The court sided with the bank. It said the bank knew the directors could borrow under their articles. That's the constructive notice part. But the bank was entitled to assume the internal requirement the shareholder resolution had been met. They didn't have to inquire into the indoor management of the company.
So if an act seems legitimate based on the public documents and the officer's apparent authority, outsiders can assume the internal boxes were ticked.
Generally, yes. If the directors or officers are acting within their apparent authority, consistent with the articles, outsiders can assume internal formalities are complete.
Seems like a vital protection for smooth business dealings. But surely there are limits, exceptions where you can't rely on this assumption.
Absolutely. The protection isn't absolute. The source highlights several key exceptions.
Like what?
One is actual or constructive knowledge of the irregularity. If the outsider knew or reasonably should have known from the circumstances that something was wrong internally, they can't hide behind the doctrine.
So if you're aware the proper procedure wasn't followed.
You can't then claim you assumed it was. The Howard versus Patton Ivory case is an example. Directors issued debentures to themselves without proper approval. They obviously knew about the irregularity. Morris v. Cancine is similar. A director involved in an irregular share allotment couldn't rely on the rule.
Makes sense. If you know it's wrong, you can't assume it's right. What else?
Another exception is suspicion of irregularity. If the transaction itself is inherently suspicious, unusual, or outside the ordinary course of business for that company or that type of officer,
The outsider should ask questions.
yes. They are put on inquiry. They can't just blindly assume everything is fine. The Anand Bihari Lal case is cited an accountant trying to transfer company property. That's unusual for an accountant's role. It should raise red flags.
Right.
Or the Houghton & Co. case, where a director used one company's money to pay another company's debt again, sufficiently unusual to warrant investigation by the party receiving the funds.
So if it looks fishy,
Yeah.
you have a duty to check. What's the final main exception?
Forgery. The doctrine of indoor management provides zero protection against forgery. A forged document is a nullity from the start. It doesn't represent a valid act of the company at all.
Because it wasn't authorized in any way?
Exactly. The classic case is Rubin v. Great Fingal Consolidated. The company secretary forged directors' signatures on a share certificate. The court held the Turquoise rule doesn't apply to outright forgery. The certificate was invalid.
Forgery invalidates everything. Okay, so summing up. Constructive notice says you're deemed to know the public docs, MOA, AOA. Indoor management says you can assume internal procedures were followed unless you knew, or should have known, about an irregularity, the deal looked suspicious, or forgery was involved.
That's a great summary. It's about balancing the need for outsiders to respect the company's legal limits with the practical need for business to function without constant internal audits by third parties.
This has been a really thorough deep dive. We've covered so much ground. The legal nature of a company, the veil, the different types, formation, those crucial documents, MOA and AOA, and these key doctrines.
We have indeed. From the basics of separate legal entity and perpetual succession, through the nuances of lifting the corporate veil, classifying companies by liability, members, control, capital access, then incorporation, the role of promoters, the details of MOA and AOA, ultravires, and finally constructive notice versus indoor management.
It really shows how understanding these core ideas is just essential for anyone involved in business, entrepreneurs, investors, managers, even employees or customers interacting with companies.
Absolutely. And it does make you think, doesn't it? Consider that corporate veil in today's world of massive multinationals with complex structures. How does that affect accountability across borders?
That's a huge question. Or think about the choices involved in setting up why choose a private company over an OPC, or when does becoming a public company make sense? How do liability and control factor into those strategic decisions?
Exactly. These aren't just abstract legal concepts. They shape real-world business strategy and risk management.
Really fascinating stuff. Perhaps you, our listener, might now be curious to explore a specific area further. Maybe dig into the rules around Section 8 companies, or look deeper into the process for altering an MOA based on your own interests.
Definitely a lot more detail to uncover in the Companies Act itself if you're so inclined.